is 80 pounds. My dog doesn't want me to bring home the cat. Just say. So if you
please adopt
want
me.
the cat,
I'm up for adoption for any home that wants a little kitten.
okay.
Say hi. Say hi. Say, please adopt me. I'm up for adoption for any home that wants a little kitten.
Matt, this is Debbie. I think we should start.
Great. Hi, good afternoon. This is Matthew Dietz. I am Litigation Director of Disability Independence Group. And today we're going to have a seminar which I'm sure that you will always remember on Do You Know Your Assistance Animals? This little dog, a picture was given to us. I'm not sure exactly what little dog or whose little dog it is, but it is adorable. So I put it as the cover page. The next page. Next. So this is an area which a lot of lawyers have difficulty in, and a lot of condos have difficulty in. And a lot of times folks do it wrong. They don't know what to ask. They don't know what to do. Also, the tenants have no idea what to ask and no idea what to do. So what usually happens is either it leads to eviction of a tenant who didn't ask correctly, or a housing association, a landlord, a condo that really is heavy-handed and asks for too much information because they're really not sure what the law is. Next. Now, this is a new case that Chris Brokus was representing Raymond Bishop, and he had 2 service animals, and this case ended in tragedy. And this is what could happen. And this was a news report that came out about 2 weeks ago. That's not it.
Story that shocked us all just last year. An elderly military veteran with a gun shot down by police in a hail of bullets.
And tonight, Local 10's Amy Viteri shows exclusive body camera video here that shows how and why it all went down. And more importantly, how possible discrimination by the man's South Florida apartment complex could have led to his death.
Listen, man, please, for the love of God, man, please put your hands up.
This exclusive body camera video shows the desperate standoff between Miami-Dade police officers and 84-year-old Raymond Bishop, a military veteran threatening to shoot himself in his apartment.
I do not want to hurt you.
I understand that.
Sir, you are a veteran. You are a hero to us. Please, please do not do this.
The video from February of last year, when a 911 call from Bishop's VA social worker brought police to the Hidden Grove apartments near Homestead.
He told me he was going to kill his 2 dogs and himself. I would say he's grossly depressed because the place where he's living is evicting him.
It ends tragically when Bishop raises the handgun. Officers shoot him 6 times.
No! No!
The reason for the conflict? An ongoing legal battle with management at the Hidden Grove apartments who were trying to evict him over his 2 service and emotional support dogs.
It ended horribly and it was unnecessary.
Attorney Matthew Dietz is now representing Bishop's family in the ongoing eviction case. The veteran suffered from physical and psychological disabilities. Records show the complex started trying to kick him out in July of 2017 after one of his 2 small dogs was off leash and nearly bit a resident. But neighbors say the woman was fine and didn't want to take any action.
La muchacha que los perritos la arañaron retiró los cargos y ellas siguieron porque querían el apartamento, punto.
Bishop immediately went to his doctors at the VA, who provided letters saying his 2 dogs, Ranger, 10 years old and blind, and Roxy, who's deaf with a deformed leg, were essential to his well-being. Letters attorney Dietz says the complex ignored.
This is one of the largest management companies in the state of Florida. They're trained on the Fair Housing Act.
And we're having a very hard time finding him any accommodations that will take care of the dogs.
Bishop left a suicide note addressing the housing dilemma. I am incapable of keeping myself and my very precious friends, Ranger and Roxy, in reasonable comfort and good health, there being no place that we 3 can go together.
They were his reason for living and waking up in the morning, and when he thought that he couldn't have them anymore, he killed himself, technically, by using the police.
Crime scene photos show one of the dogs hiding in the bedroom after the shooting. Both dogs are now living with a friend of Bishop's.
We're here to ask you about Raymond Bishop, the man who was evicted. Any questions?
Management at Hidden Grove had nothing to say when we asked about the eviction.
This lawsuit says that because you guys are illegally evicting him, he lost his life.
I will not answer any questions.
It's not right to treat people that way.
Bishop's granddaughter, Ashley Huntsberry-Lett, spoke with us from Virginia. She says management bullied a fragile man to his breaking point.
I feel that they're 100% culpable. He was a disabled man who had nowhere else to go.
Dietz says the complex had an obligation to try to fix the issue before evicting Bishop, and an opportunity to show compassion.
They know about what emotional support animals are, and they knew what to do in this situation, and they chose not to. And that's why Mr. Bishop is dead.
The legal case between Bishop's estate and the complex management is moving forward, but in the meantime, Bishop's family says their main goal is to prevent something like this from happening to someone else's loved one. Amy Viteri, Local 10 News.
And even more, Amy tells us Bishop's family also says his computers and television seen in police photos were missing from his apartment when management finally allowed relatives to enter. An attorney representing the complex did not return our calls for comment.
A story that shocked us all just last year.
The next video I'm going to show you is a little bit
He shows exclusive
happier.
body camera video here that shows how and why it all went down. And more importantly,
the video is one of my favorites. It's Snoopy Come Home, and this was back in 1973. And nobody really understood what this was in 1973, other than Snoopy was actually one of the first emotional support animals. And you could see, and this is something that will never leave you, and I promise, how Snoopy wasn't allowed to live with Lila because of the fact that Lila lived in a no dogs allowed building. Now we're just going to turn to the part. It's an hour and 20 minutes, but we're going to show just a couple of scenes. The first one is where Snoopy receives a letter.
Here, Snoopy, you got a letter.
Once I called you my own. I'm sad as I can be.
And this was also the first appearance of Woodstock ever, back in 1973. So this is how Snoopy did his job as an emotional support animal.
Here. I hope I can go home soon. Thank you, nurse. Thank you. I'm feeling better every day. Perhaps soon we can go home. I know that when my mother sees how you've made me well, she'll let me take you home with me. I'll keep you with me forever. Well, Snoopy, this is our last day together. What are we going to do? Your coming to visit me saved me. Are you sure you don't want to come home with me? It's up to you, Snoopy. You can go to your other owner if you want to, but I wish you'd come home with me.
And this is when Snoopy finally goes back to Lila and has made the decision to live with her to make her feel better. But you see, no dogs allowed. But again, he's happy when he gets to go back to the peanut kid.
Snoopy, you finally got here. We've been expecting you. Our whole family is eager to see you again. And I can hardly wait to have you meet my cat. You'll just love each other. He's the sweetest thing.
So then Snoopy comes home, and the Peanuts gang is so happy to see him.
Our friendship joins in our close united status. Who could ever separate us? And what's more,
Hey, he's back! Huh? He's back! He's back! He's back! He's back!
harmony is where it's at, and where it's at for you is where it's at for us. Share and share alike is what it's all about.
So now that is probably the only Sealy that you're ever going to see that has a Peanuts cartoon in it. But the interesting thing is a lot of questions come from that. Like, let's look at the next slide. Is Lila, is the first one, is Snoopy an assistance animal? The first question is Lila a person with a disability? Then, is Snoopy a service animal or an emotional support animal? Is Woodstock a service bird? Or is Woodstock an emotional support bird? Are Snoopy and Woodstock allowed in a hospital? And are Snoopy and Woodstock allowed in Lila's apartment? Now, the first question, let's go to the next slide, is what is a service animal under the Americans with Disabilities Act? A service animal could only be two different animals. It's a dog or a miniature horse that is individually trained to assist a person with a disability. Those are the only two animals. A monkey is not, a cat is not. It has to be either a dog or a miniature horse. A service animal is permitted in all public accommodations in state and local governmental facilities. Next. Then you have a different law. What animals are permitted under the Fair Housing Act? Under the Fair Housing Act, the difference is any animal is permitted, and is permitted as a reasonable accommodation under the Fair Housing Act if the animal is necessary for persons with disabilities equal use and enjoyment of the premises. It does not have to be individually trained. It just has to be necessary for a person with disabilities equal use and enjoyment of the premises. And it could be any animal. It could be a monkey, it could be a snake, it could be a chihuahua wearing a dress. Next. The next is what does necessary mean? And this term has actually been litigated. Necessary means the animal ameliorates or lessens the effects of the disability. So if by hugging the animal, it lessens the effects of anxiety or depression, or if you dress your dog up as an Ewok, that would, and it lessens the effects of your disability, then it would be allowed to be a emotional support animal. Next. The main difference between the ADA and the Fair Housing Act is the type of animals permitted and the training. Under the FHA, any and all types of animals, subject to the animal being a direct threat to the health and safety of others or unreasonable, it can be an emotional support animal that provides emotional support, well-being, comfort, or companionship for a person with mental illness or a psychiatric disability. On the other hand, the ADA specifically exempts tasks including emotional support, well-being, and companionship from the definition of a service animal. And the reason why is that a service animal has to be individually trained. An emotional support animal does not have to be individually trained. That's why you could have a snake as an emotional support animal, because it's really difficult to individually train a snake. Next. I love this cartoon. Hey dude, can you send a service dog for some ketchup? Is it individually trained? So when you look at the tasks for a service animal, it could be any tasks for a person with a disability. And that's why you really do not have any official certifications for a service animal, because it's dependent upon what that person's disability is. For example, the next one is a hearing dog for the deaf. Do you want to play a minute of this, Deb?
There's no sound, only American Sign Language and captioning.
These are a series of videos that were produced for HUD involving fair housing and accommodations for people that were deaf. And they were done in sign language so deaf people could actually understand what their rights were. So this, can you forward it to the dog part? So in this one, which doesn't have the dog in it,
I can find it if you want, or we can keep moving forward.
Yeah, let's keep moving forward. What the dog does for the deaf person is it alerts the deaf person to sounds, somebody knocking at the door, somebody coming behind them, something that would ameliorate the effects of the person's disabilities. And also, there's also folks that have mobility impairments, and the dog would pull them or pick something up for them. There's dogs that assist people with psychological tasks. For example, a person with autism, it helps a person with autism by preventing or interrupting impulsive or destructive behaviors. It could remind an individual with mental illness to take prescribed medications. It could calm an individual during a post-traumatic stress disorder, during an anxiety attack. So there's many different tasks that a dog can be trained for, but you must remember that a dog only needs to do one task for it to be deemed to be a service dog. So it has to be individually trained to do one task. Next. Now, the problem that you have when you're dealing with condominium boards or homeowners associations when they have a no dog rule is they're really into their rules and they feel that they must maintain their rules to the detriment of anybody who needs an accommodation for them. And sometimes the attorneys have no idea and they just follow the requests of their association without ever checking into what the law or the medical or what the requirements are of the Fair Housing Act or of accommodating a person because of a disability. Next. One of the most frequent ones is when somebody requests an accommodation, they ask for copies of all of the medical records or releases to obtain medical records from the doctors or to ask statements from the doctors. They cannot do that. The only material that a landlord or a condo association is entitled to have is only the information that's necessary to apprise them of the disability and the desire and possible need for accommodation. There are no magic words to request an accommodation as long as they convey the intent that they have a disability and they need a modification of a rule or they need something for their disability. Next. One of the main things that comes up is what proof is needed. If a disability and the need is apparent, there's nothing needed. For example, if a blind person has a guide dog, if a person in a wheelchair has a service animal that follows them around and it's obvious what the animal could do, you don't need any proof. If not, a housing provider can request documentation from a physician, psychiatrist, social worker, or any other mental health professional that the animal provides emotional support that alleviates one or more of the identified symptoms of an existing disability. So it's a verification of what the animal does and what the disability is. Next. So the question is, what should be requested for a housing provider? A housing provider may request reliable disability-related information that is necessary to verify that the person meets the Fair Housing Act's definition of disability, describes the needed accommodation, and 3, shows the relationship or nexus between the person's disability and the need for the requested accommodations. Usually, if you if you have cases against subsidized housing or public housing providers, they even have forms, verification forms, that could be provided to the tenant to give to their doctor to fill out, which is going to basically say, my patient has it, I've been treating them since X date, my patient has a disability, describe the accommodation. And all the person says is the person needs an emotional support dog for their depression or anxiety. Next. What I usually do in my cases, if I'm guiding a tenant to make a request, I say you have to get a letter from your social worker or your doctor. It must describe the relationship, because so often you see those internet letters where somebody pays $49. So it's better to use a doctor that has an ongoing relationship with the patient. The type of disability. You can't say I have a disability. You really have to say what disability you have, especially when it's not obvious, because all of these issues that are provided to housing associations or housing facilities should be confidential. The disability has to create a substantial limitation of a daily life activity. That's the definition of a disability under the ADA and the Fair Housing Act. And the nexus between the animal and the disability. It's not obvious what the animal does. If the person says, you know, my patient Sam has a disability and he needs his dog, that's not going to be enough. Really doesn't say what the disability is. It doesn't say what the purpose of the dog is. So next. So when I do the request itself, along with the doctor's letter, what I do is I try to be as specific as possible because I want the housing facility to be put on notice that this is a requirement under the Fair Housing Act, especially if they come to me after being denied or the housing provider has no idea what's happening. What I do is, along with the doctor's letter, I state that the request is a request being made for reasonable accommodation under the Fair Housing Act, that the client has a disability and the animal is necessary to ameliorate the effects of the disability. I include a copy of HUD's Notice of Service Animals and Assistance Animals for People with Disabilities in Housing and HUD-funded programs, which was published in 2014, and it's on my website if anybody wants a copy of it. And I also remind the facility that the client's disability is confidential and thus now must be shared to any other person in housing unless it's necessary to do so, such as the board members that may approve or disapprove an accommodation. Next, I'll tell you about a trial that I had in Orlando with Ajit Bogaita and his dog Kane. And that's a copy of us in federal court where we should be taking pictures. Kane, it was a 85-pound pit bull. And Ajit was a veteran who was a victim of military sexual trauma when he was overseas. He believed Kane was his emotional support animal. And he wanted to keep Kane in his home. Now, turn to the next one. However, the problem that they had is the governing documents prohibited dogs over 25 pounds from residing in the unit, and he provided letters from his doctors from the VA saying that that this was his emotional support animal and that he required it because of his depression. So they wanted details, the exact nature of his mental disability, the treatment he's receiving, a list of all medications, the number of counseling sessions, how the diagnosis was made, the total number of hours and sessions of mental health treatment that they received, how long he's been a patient, whether the condition is permanent or temporary, what treatment he is prescribed for moving forward, how the disability substantially limits the major life activities, and why you need a dog over 20 pounds, why a smaller dog won't suffice to have an equal opportunity to use and enjoy the units. But that wasn't it. Next page. Then they wanted a list of each individual disability. Well, hold on. Is this the right one, Deb? Oh, and go to the next one. And they wanted all of this information. They wanted information about all the disabilities, any other medical professionals, everything that you could imagine, including the training for an emotional support animal. This actually had to go all the way to trial. Initially, we prevailed on summary judgment when the court said that this was just too much information. And the whole issue was whether or not there was ever a denial itself, because he continued to live there. And the court found after trial that the significant delay constituted a denial, and that you really can't ask these many questions into the nature and extent of a disability. It's just another barrier that these associations put up. And you will see in a lot of the rules and regulations of housing providers that they have all of these additional barriers, which are all unlawful. Next. The next case is Fisher versus Sable Palms, which was a 2014 case. Deborah Fisher was a retired school teacher with multiple sclerosis who had a professionally trained service animal from Canine Companions, which is one of the best service animal training schools in Florida. There was no question that she had a disability. There was no question she needed a dog. However, the association did not allow dogs. Next. So again, they knew that there was a requirement to make a reasonable accommodation, but they said, we're allowed to ask you questions. We want copies of all your medical records. We want to know we want to know what the diagnosis, what treatment is, what about your disability about you that you need a dog in your apartment. And this woman was in a wheelchair. She had limited ability to grasp, and all documentation relating to the nature, size, and species about the dog, as well as the documents you received. So it was absolutely crazy with regards to what was asked and what she had to provide. Now, the interesting part about this is we went to a summary judgment, and Judge Scola issued a 61-page order on summary judgment, finding that essentially the attorney should be sued for giving such a bad advice to the condominium. But essentially, Judge Scola said that it was obvious what her disability was, and they can't ask those invasive questions, and they were absolutely incorrect for doing so. The depositions in this case were so interesting because they actually asked her, so your dog opens up doors and cabinets for you? Why can't your husband do that? So it's definitely these things arise because these rules mean a lot to these associations, and I think what they do is I think they stay up late at night and they think up how many rules can they possibly make and how difficult can it possibly be. But we're going to look at some of those rules. Let's go to the next one. Now, a lot of these rules come from the same properties. So again, even though they know about assistance animals, service animals, or emotional support animals, they still maintain that they could ask how many questions in compliance with different requirements. Of course, you could ask for vaccines and stuff that is normal. But if you look at number 3, residents who had any animal on the property as the effective date of this rules must apply to have an animal approved as an assistance animal. This is necessary even if the resident obtained prior permission, written or oral, for the animal before these rules went into effect. No, once it's approved, it doesn't have to be reapproved unless there's some reason, verifiable reason, that the disability changed. Next. There are also some other rules that you'll see. If the owner or resident, and that's our dog who doesn't like the stray cat, procedures for a person seeking a modification, waiver, or exemption to a pet restriction. Now, this one says they must follow the following procedure to the fullest extent permitted by law before bringing the pet into their unit and upon association property. That is wrong. There are no formal required procedures to ask for a service animal or an emotional support animal. You could ask for a service animal, make the request at the time of eviction. You can make the request at the time of the 7-day notice to cure. The only requirement you have for making there is no formal requirements even for the request. The request does not have to be written. The request can be verbal. It's good form to be sure to put the request in writing because you know that a facility will always say that a request was never made. But there is no requirement by certified mail, return receipt request, or anything like that. So these procedures for persons seeking a modification, waiver, or an exemption to the pet restriction cannot be mandatory and cannot be enforced. Next. This is another one, procedures for requesting requests for modification, waiver, or exemption to the pet restriction. Now, the associations make it so difficult, it's almost tantamount to a denial. So this one, the association wanted to conduct an inquiry to the fullest extent permitted by law to verify whether the unit owner and resident is entitled to such a modification, waiver, or exemption. So they want an inquiry by the board of directors, including their attorneys or other professionals, a review of the supporting records of the experts who provided an opinion. Next page. The conducting of an examination, question and answer session under oath, written or oral as determined by the association of the unit owner, the conducting of an examination, question and answer session under oath of all experts who provided an opinion or recommendation that the unit owner or resident has a need or entitlement to a modification, the conducting of an examination under oath of the trainer, then they need to get all documentation at their own, at the requester's own expense within 20 days of the association's request. And then the person must pay the fees of the doctor being examined. Next. Then if they fail, and if the trainer or experts fail to do it, the association may deny the request. And then all in all, at the end, if the association denies or approves, it may request the declaration by an arbiter, court, or other tribunal with appropriate jurisdiction regarding whether the modification, waiver, or exemption to the pet restriction is required. This was actually the rules in the Sable Palms case. And this is one of the reasons why Judge Scola went off on this. So then the next page, then some of them also have procedures for keeping a pet. At all times when a pet is outside the unit, it must be maintained under control of the resident or owner, maintained on a leash no longer than 6 feet in length, prevented from approaching any other person, animal. In the case of a pet over 20 pounds capable of biting, such as a dog, it must wear a muzzle. You know, if the dog is a direct threat, and we're going to go into what a direct threat is, the dog wouldn't be allowed. There is no requirement for a muzzle. There is a requirement to keep the dog under the user's control. In the case of all pets that are capable of biting, aren't all pets capable of biting? The owner or resident will be required to keep and continuously maintain and show proof of liability insurance for coverage or keeping a pet, including coverage for bites, with the association as an additional insured and the amount required or otherwise permitted by law. This would be considered to be a surcharge on a person with a disability, so it would be considered to be unlawful. Next. I've had cases solely on the terms and conditions. In this case, McHale versus Waters Edge Association, the association required the dog to have a photo ID card, liability insurance, and it limited the type. Go to the next one. Next. It limited the type of therapy animal or service dog to one small domesticated animal per person. Excuse me. So, and then if you go to the next one, Then it limited the type of dogs, and it limited the weight of dogs. Rules limiting the type of dogs or weight of dogs are unlawful. Rules saying that, as a number 9, all service or therapy animals coming into and out of the building must be in a carrier or must be held until the pet is off premises is unlawful because it denies the person equal use and enjoyment of the premises, including the common areas. So a dog can go in the same elevator as anybody else. The dog could go in the same laundry room as anybody else, as long as the other person doesn't have an allergy, and then you'd have to weigh the accommodations for both persons. Next. And when you talk about common areas, you cannot have rules that service or therapy animals are not permitted to use or walk and run on the common areas or elements. A person with a service animal is entitled to use the common areas like anybody else is permitted to use the common areas with their animals. The only issue, unless it would be for some reason unreasonable or a direct threat, one of the things that people have asked me is, can I bring my dog in the pool? And I say, no, that's really not a good idea. There's health reasons, and there's no reason why you need your dog in the pool. 11 is one that I also like. The association shall have the power to determine if the service or therapy animal has become dangerous, vicious, or obnoxious to others. I don't know. I mean, I would love to try to evict obnoxious neighbors. It would make life so much easier. I don't even know what these things mean. Okay, next. And this was all in one case, the McHale versus Water's Edge, and there's 2 more pages of these. Under no circumstances are unit owners, guest, family, and this is also like a primer in what you can't ask. Under no circumstances are unit owners, guests, family, invitees permitted or to bring therapy or service animals onto the condominium property at any time for an overnight or another interim stay. So your blind friend that has a service animal can't bring their dog here. No, it doesn't happen. I've actually had one case in which a woman came down from the Northeast with an emotional support dog to stay with her friend in Florida for a month, and that's fine as long as a request is made. Therapy animals, service or therapy animals are not permitted in the pool area or the pool, lavatory, stocks, the grass, or landscaped areas of Water's Edge. Of course, they're allowed to be anywhere else where anybody else is. Residents with a therapy or service animal will use a south side, poolside, ground floor washer dryer beside the door only. So if you have a service dog, you can only use one washing machine and one dryer. No. Again, a person with a service animal is entitled to have equal use of the premises. Next one. A resident or any other person may call the police department to complain about a service or therapy animal being a nuisance. After calls to police, report will be turned over to the City of Coral Gables, where the owner will be warned or fined by the city. This is just a threat. It's retaliation. It doesn't happen. Each unit owner otherwise permitted to have a service or therapy animal in his or her unit shall be liable for all costs, expenses, and attorneys without regard to whether litigation is commenced, which the association incurs to enforce the tenants or unit owners' obligations under these regulations. That would be, I actually have a case right now about that exact thing, about being charged attorney fees in Broward Circuit Court. That would be another form of discrimination or retaliation. And it goes on. This is one place. Next. The association shall have the power and authority to levy fines which the unit owner must pay in an amount in excess of $100 per day up to $1,000 per violation of these regulations. No, you can't fine somebody for the use of their service animals. Then they have the power and authority to seek specific performance. Again, violation of the Fair Housing Act, number 20. Now, this is another thing which is unlawful. Each unit owner otherwise permitted to maintain a service or therapy animal in the unit shall provide the association with a $500 non-refundable fee. If the unit owner violated these regulations, the required non-refundable fee shall be increased to $1,000. That's a surcharge. And then 22, withhold the consent to the sale or rental of a unit by such owner until all fines or other obligations owed by the owner under these regulations, including but not limited to costs and attorney fees, are paid in full. So that would be a denial of the sale or rental of the unit because of a disability. This was all from one association. So you had 22 rules that were all on their face a violation of the Fair Housing Act. And this association, this was a Coral Gables association, and you know that they had a condo attorney there drafting the rules saying, you know what, I think that's a good idea. I think it should be $500, and if you violated it, it should be $1,000. I mean, you look at things like that, and these things are not unique. And I still get cases now, and this is a case that was the McHale case was about 4 years old, but I still get cases now that really have similar rules. So whenever I have an issue involving any type of reasonable accommodation rules, the first thing I ask for is the rules and regulations and terms and conditions, because you know that the rules there are going to be unduly restrictive, especially when they enforce the rules, and it shows that these folks have never had any training with regards to the Fair Housing Act. Next, the exceptions. Is the dog a direct threat? Does the specific animal pose a direct threat to the safety that would cause substantial physical damage to the property that cannot, or a person, that cannot be reduced by another reasonable accommodation? This is an individualized inquiry. Of course, a dog like Cujo would be a direct threat. A dog that dug a hole on the side of the property, could that be fixed by another a way to minimize the property loss? Yes, you could put a fence, you could put chicken wire by the dirt. It would be a cheap and inexpensive way to do it. Now, in Miami-Dade, of course, we have the issue about a pit bull. And with pit bulls, and with pit bulls, you know that Miami-Dade has an ordinance that you cannot have pit bulls within the county because in general, Miami-Dade has made a determination that pit bulls could be dangerous. Let's go to the next slide. And this, as you could tell, is from a U.S. and global condo firm, which I'm sure that you probably know the two letters that used to be Becker and Polyakoff. And they used to have a letter that says, you've been advised by the association's manager that the dog is likely a pit bull and prohibited from being in the housing development. And let's turn to the next one. And again, dangerous, poisonous, or illegal animals are not permitted. This includes animals without limitation, pit bull breed dogs. Pit bulls or any other animal, and it doesn't matter what type of animal, have to pose a direct threat. So in order to determine whether or not an animal is a direct threat, an individualized inquiry must be done of that animal. So you can't assume that because an animal is a pit bull, it is a direct threat when the person claims that that animal is an emotional support animal. And there was actually a case that decided this, Warren versus Del Vista Properties. And it was a case in which the judge said that the Fair Housing Act supersedes the local ordinance. and therefore it would have, the individual animal would have to be a direct threat for that animal to be not to be included under the Fair Housing Act. So a lot of folks that have pit bulls claim that their animals are an emotional support animals, and that would be an exemption to the county ordinance. The next one is animals that are ill and poor health may not be registered as an assistance animal. Again, I always think if management reserves the right to remove from the property assistance animals that are ill or in poor health. These rules came from a Section 8 subsidized housing facility. And I always thought that this was the meanest rule. If the dog is not a direct threat, it doesn't matter if the dog is ill or if the dog is in poor health. Only if the animal is a direct threat do they have the right to say that the animal could be removed. Next. So the issue, the whole thing is, don't make Lila cry. You saw Snoopy, you saw Lila. And folks, housing providers can be mean. Can you do the following action? Can you charge a fee for the request for an emotional supportive service animal? No. Can you charge a pet deposit? No. Can you require the use of a service elevator for somebody who wants to have their dog? No. And I have my two interns here, and they're all nodding their heads no. Can you limit the dog to a certain area of the facility? Can you say that that no dogs are allowed in the card room? No. Can you require dog insurance? I actually had a case in Broward County where the school that refused to allow an epileptic service dog into the school because they did not have specialized service dog insurance. And they said, you know what? We looked it up on Google, and you could get it up by this company called Fido. No, you can't require dog insurance, and you can't require the dog to be muzzled. One other topic that I want to address before I go into questions is what I often find, especially with letters from professionals, and I didn't touch on it enough, and that's always something that comes up. A lot of folks believe that they can go on the computer and buy a vest or buy a card, and therefore their dog will magically become an emotional support animal. Whenever I have a client, I go, that's really not enough. You really have to go to your own doctor. You have to get a letter from your own doctor. There is no registration for service animals or support animals. Any registration for service animals and support animals is fake. There is no specified clothes for service animal or support animals. They don't have to have a specialized leash. They don't have to have a specialized vest. You could buy the leashes and vests on Amazon for $60, $30, whatever you want. I actually wore one once for a Halloween party, and I dressed like a dog. But there is no magic words to request an accommodation. There is no magic to writing a letter. The issue is a doctor has to say, a doctor, a social worker, a healthcare provider has to say the person has a disability and requires the use of a service animal to lessen the effects of their depression, their anxiety, whatever their disability could be. So Lucy has questions. Lucy, can you please be quiet? So, and here's a picture of Lucy, and you're hearing Lucy in the background. So you could either type out your questions, or if you put your microphones on speaking, you can ask questions. Questions? So do my interns have any questions that are here?
It looks like Sherry has her hand raised.
Oh, I can't tell. Deb, can you? Sherry, what is your question?
Maybe it's old from before.
Does anybody else have any questions? Okay, well, thank you so much for attending. If you have any other questions, you can feel free to email me or call me. I'll be more than happy to assist in any way possible.